Okay, so yeah, great to see the same people logging on regularly, and welcome to those of you who haven't come to any of my sessions. I've been quite enjoying this, and hopefully you guys do find it useful. So yeah, we're just going to discuss powers of attorney. This is a regular situation that we have with property transfers, and we find that it's a cause for great frustration because people try and plan their exit, or if they're going on holiday or anything, and they want to leave a power of attorney with somebody because they're trying to deal with their property, and we have to then say to them, I'm sorry, only half the documents are there, we still need you to sign. Okay, someone's not on mute. I just don't want to carry on until. Okay, hang on. Sorry, my thing is stuck here. Okay, so types of powers of attorney. So you got a general power of attorney. This is quite self-explanatory. This is where someone intends for another person to manage their affairs generally. The special is for a specific task. So you're buying, you're selling, you're letting, you're renting, you're bonding, etc. If the document doesn't specifically authorize an action, you can't use it. So even in a general, it needs to say, in respect of XYZ, otherwise we can't use it. Okay.
Coming for training.
Sorry, I just want to see who's.
Kelsey is responsible.
Who's not on mute. Sorry, I've got to turn these cameras off and whatnot because otherwise you get on the video.
Why can't I move this?
I think I found the person. Okay. Let's try it again. All right, so the requirements to use a power of attorney to pass transfer in the deeds office in particular, there's quite a lot of things you need to note. So hopefully these notes will help you going forward. There's a prep clause. So at the top right-hand corner, an attorney needs to have drafted the power of attorney and needs to prepare it. That's exactly what happens, what's written there. Some people, if they've used like a CNA one or whatever, we can fit that in, we can handwrite that at the top, but you've got to put an attorney or a conveyancer who's prepped it, okay? You have to have full names throughout the documents. Please don't use abbreviations. You have to write the marital status of the person as well. And I'll go through how to cite all of that. And if you're married according to the laws of a foreign country, that person needs to be included in that document as well. Okay, so there's an example just of a person who's unmarried, but that is the format of the person who is giving the power of attorney. If the person's married antenuptial, there it is, just married outer community of property. Then it gets a bit more tricky. If they're married in community, but only one person's giving the power, you would cite it like this, married in community of property 2, or if both are giving you, then you would say married in community of property to each other, okay? And they would both sign. If you've got somebody who's married according to foreign law, then they need assistance, as I've mentioned. So this is how you cite them, their ID number, or if they don't have an ID number, the passport number, not born on, let's say born on, not passport number, born on, marriage is governed by the laws of England, for example, and duly assisted by his wife, identity number or born on as far as needs be. Now, in my other sessions, I would have told you that the assistance of a spouse in a foreign marriage doesn't give them rights to proceeds. That would depend on the laws of that country that they are married in, but our deeds office want to make sure that the spouses of someone dealing with property locally in South Africa actually know what's going on if they are married according to foreign laws. Okay. Hindu marriages, please remember that's actually considered unmarried, or you could say married according to Hindu rights, but only one person would need to be on the documents. If they're buying, if they're selling, you would look at the title deed. Muslim marriages, you've got to be a bit careful. Back in the day, Muslim marriages were not recognized, and they're actually still not, but what happened was the imams got registered as marriage officers, and so the normal laws, if the person who married them after 2014, I think it was, if they were registered imam, then you would follow the normal laws of are they in or out of community of property with an anti-nuptial contract and whatnot. Okay, customary marriages, that is recognized marriages. Those are recognized marriages. There's an act which specifically deals with that, and those are considered in or out of community of property, depending on if they've got an anti-nuptial contract, if they second marriages, etc. Okay. Now, the person in whose favor you are giving it, you only have to do their full name and ID number. We don't care about how their marital status. Okay. All right. So if you sign the power of attorney in South Africa, it's no problem. All you have to do is initial each page, sign in full on the last, have 2 witnesses that do the same thing, and sign in black pen. If somebody wants to and they are going overseas, they often appoint me or my staff as their representative. That's fine, but I do not like to sign sale agreements. Sale agreements you can scan anywhere in the world or email, and they can at least, at minimum, come back to you and say they're happy with all the terms, and then I would sign, because your sale agreement is your starting point, and you know, that's where the landmines can come in, or it's the minefield. So they must be responsible for accepting all those terms, and then I usually just do the transfer documents, which are just a matter of process, and they don't create any extra rights from after the sale agreement. Okay. The person in whose favor must not sign or witness, but there must be random people or independent people. If the client's signing overseas, this is where it gets complicated. We have to send them to a consulate or notary public, because the minute you say signed in and it's not South Africa, these whole bunch of new rules apply on how to get the document signed. So yeah, consulate's very easy if they are nearby. If they're not and there's a notary rather nearby, then the notary would sign, and depending on the country, there may be an apostille or a notarial authentication certificate that also has to be signed, and that's signed by somebody else confirming the notary is who they are and that the notary is qualified. Okay, in Botswana, UK, Northern Ireland, Lesotho, Swaziland, Zim, we only need the notary to sign on their own, which is much easier. Okay, the signatory must affix the stamp. So if you go to the consulate or the notary, they must put their stamp, they must sign, and they must write signed in my presence, and then there must be the witnesses. You'll be amazed at how often the people get these signatures wrong. So what we say is, please send us the documents once signed before you courier them back to us, so we can check that there's nothing missing there. The deeds office literally is so strict that if a signature is missing, they will chuck the whole thing out. Okay. If the seller has issued a special power or general power, we need to lodge that original in the deeds office with the other transfer documents. So that's why I say it's really important how they sign in black pen, etc. If they sign in blue, the deeds office may accept a certificate from us to say that it was out of our control that they signed in blue, but it's not ideal, and you might get an examiner who's just been difficult because they don't have to accept it. Okay, ensure the tasks as a grantor are allowed in the document. So if it's a buyer and they're wanting to take a bond, there's a whole bunch of extra clauses that need to go in so that they can sign all the bond documents as well. Okay, what other documents do we need? This is where there's a misconception, or just sign a power of attorney and off you go. No, 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 we need a lot of other stuff. So we need certified copies of all their documents. If there's bond attorneys, they'll also need originally certified copies, so we'll ask them to get 2 sets. There's a FICA affidavit and a FICA questionnaire for us to do our due diligence. You all know you're meant to be doing due diligence on clients in respect of FICA. If a client's lost their title deed, the application can only be signed by the client, nobody else, because it's in their personal knowledge that they've lost this document. If there's an error on the deed in respect of their names or marital status, only they can sign that application. So their power of attorney won't work. So we have to try to figure all that out as well. If it's in respect of a condition, a title condition or something, then we can certify or we can sign those applications to say that there's an error because it's not personal, right? If someone's acting on behalf of a trust company or CC, it's much easier to just do the resolution then. Don't do a power of attorney, do a resolution to act on behalf of the entity, but I can guide you if you need clarity on when to use what, okay? So when can't you use your power of attorney? So if somebody has lost their faculties or doesn't have all their faculties, they're confused, maybe they have Alzheimer's, or their health is deteriorating to such a degree that they don't have lucid intervals, or they generally just don't know what's going on and they forgot that they've even signed this document, then please don't allow them to, because you will find a beneficiary or a child or something coming out the woodwork to say, how on earth did this go through? My mother didn't know what she was doing, okay? So just be very careful that you actually meet the client if there's any talk about that situation, okay? Or at least you maybe have communication with the person who signed them up or something. If they become incapacitated, so they're in a coma or yeah, they just don't know what's going on, that you can't use the power of attorney. Or if they die, then the power of attorney dies with them. You can't use it once they do. So yeah, just be very careful about who you allow to sign powers of attorney if you know there's a mental health or anything like that situation involved, okay? So with just in regards to our transfer, if somebody passes away, then we have to stop the transfer. So if a seller does, the heirs are under an obligation to abide by the contract because it was signed during the deceased lifetime. What we will have to do is we will have to get the heirs to go or the executor to go get appointed. They will send us their letters of executorship. We will amend our power of attorney, and we will have to send that to the master with the heirs' consents to sign our documents. Okay, if it's a buyer, if they're buying cash, they're under an obligation to proceed. If they are taking a bond, however, that is a personal situation that nobody else can actually take over. So the deal may have to crash. Okay. So incapacity, there is a presumption that everybody over 18 has their contractual capacity until they're proven otherwise. So if you have a situation where the family member doesn't believe that the person has all their faculties or is not capable of making good or proper decisions, they must go to the courts, high courts, to get the curator appointed. Okay, usually it ends up being a 3 appearance process, and doctors and experts have to give their opinions. If the person's in a coma, for example, well, that's very simple. It won't be disputed, etc. But if someone actually, doesn't want to, believes that they're actually fine, they could dispute it, and then it could have various appearances and get a bit expensive. Okay, so the cost generally is between 30 and 50,000 Rand, depending on the experts, the appearances, and the counsel charges. Counsel as an advocate, okay? So you can tell a client that it may be in their interest to pay this money so that life can continue and the heirs can start dealing with the estate, or the curator, should I say, the curator gets appointed, but usually the heirs and the spouse and whatnot usually get involved to try and push this along. Yeah, please always have some sort of contract with the seller in respect of powers of attorney, in respect of, are they okay? Do they know what they're doing? Because I had a situation where this man approached an agent and he said, look, I've got this property. It's in this lady's name. I've got this property to sell. Please help me. And they sold the property. And it turns out she, luckily during the process, contacted the agent and said, I hear my property sold. I know nothing about this. I didn't give anyone a power of attorney. She had signed a power of attorney, but she wasn't aware what it was. This man had lent her money. and now he was trying to sell the property. So what we did was we did a deed of cancellation. We wrote him and we said, you actually are, don't have the correct power. You should never have entered into this contract. You didn't have permission. We are disputing your contract, but in case you want to get clever, we are cancelling the contract. And we did a deed of cancellation with the buyer, and we said to her, look, we're actually happy with the sale. We're just going to enter into a new contract on our terms, so we've got control. I was appointed, I oversaw the thing, and if this woman had not come to fore, that agent would have never known, and a transfer would have gone through, and yeah, I can only imagine the consequences. Also, that attorney, I think, was in cahoots with him, but if he'd had all the FICA documents, then how would they know that there was a problem with this power of attorney? Okay. So if someone passes away, I wanted to explain how winding up an estate works so you can understand a sale from an heir and a sale out of the estate. Okay. So firstly, someone passes away, the heirs or spouse or family report the estate to the master. The master will issue letters of executorship for estates over 250,000. I'll tell you under 250,000 just now. And then the executor will have contractual capacity, will not have contractual capacity before getting those letters of executorship. So if you're dealing with an estate, please make sure you ask for a copy of that. Alternatively, wait for that to be issued before you action anything like a mandate or a sale. The executor has 6 months to gather the information of that deceased person, so the assets and liabilities, and to draw up an L&D account and submit it to the master. In reality, the masters are asleep. They don't actually check that anyone's only taking their 6 months. But if someone takes longer than that, there could be a complaint and they could be chucked off as the executor. So if you do have a situation like that's just been going on forever and ever, amen, there's a chance that you can get the executor removed. Okay, the master will then receive the L&D account and then will approve or query it. Usually there's queries, goes back and forth once or twice, maybe more, depending on how good the attorney or the people handling the estates are. But once approved, then the matter can lie open for inspection for 21 days. Once the time's up, only then can payments be made to heirs or properties transferred. Okay, so you've got two types of heirs. You've got testate heirs in terms of the will, so the will nominates who those people are, or intestate heirs where there's no will, the law dictates then the law will dictate who they are. This can be messy. Also, if you've got children under 18, their money then goes into the government fund, and the spouse would get a share, they would get a share of the estate, etc., but they wouldn't have access to their share. So it can be a really precarious situation. If any of you don't have wills and you've got minor children, please, please, please get them done. So before you go ahead with a mandate or a sale, my suggestion to you is you figure out who these heirs are and you check with them that they are happy with the price that you're going to be marketing it at, because they have to consent to the sale. So you could do all this work and then you have one sister, for example, sitting in Australia who thinks she wants more money and she will not consent to your sale. And if you don't consent, the master generally won't. So rather get up front that everyone's on board with you and you won't waste your time. Okay, so when you're dealing with an estate, please obtain these letters of executorship. Please get your mandate, get all the heirs to consent, and then market the property. Okay, an email for now is fine. We have to send them a specific form during our process, so an email for now. So if somebody has a really small estate, now most of you will deal with properties that are over 250,000. So therefore immediately the estate's worth more than 250,000. You only have to get letters of authority, not letters of executorship. There's no liquidation distribution account that's required. The master doesn't have to consent to our sale, and the executor can distribute the proceeds. So it's a much simpler process. The idea is that they don't want that very small value of the estate to be used up for legal fees. So yeah, a lot less formalities. Okay, if you're going to do a sale out of the estate, which if you can, you should, because the minute you the estate's reported, you only need the letters of executorship to be issued and you can do a sale. If you're doing a sale from an heir, you have to first wait for the entire estate to be wound up, and then you can do it. And often heirs have a misconception about where in the process they are, and the next thing you thought this was going to be a quick deal, but actually it's still quite a long way away. So I'll go through that with you. Yeah, so only take a mandate or offer once you've got the letters of executorship. Ensure that you get the heir's consent. Ensure you cite the seller as follows. So the executor in the estate late, if he owned it on her own, or if the wife is the executor, so her in her capacity as executor in the estate late and as surviving spouse, or if they're two different people, the executor in the estate late and her as surviving spouse and owner. Yeah, pretty simple. But there is one more clause I need you to put in the contract, and that is the parties are aware that the master is required to consent to the sale. Should he fail to consent, the agreement will lapse and be of no further force and effect. Okay, so that's your buyer can't hold anybody or the estate liable for anything. Don't say subject to, if you can avoid it. Don't say subject to the master's consent, rather just say it's recorded. So you do it as a resolutive condition. Okay, when we we try to avoid suspensive conditions at all costs if we can. Okay, so to sell out of the estate or to sell from the heir. So if it's not, the estate's not wound up and you get, let's say, a daughter come to you and she says, I don't know, I'm about to get my parents' house, please can you sell it for me? Then you must check that the estate has lain open for inspection, because remember that's a 21-day process, and then only can they proceed with the transfer. If it's just before, well, that might work, but then you need to notify your buyer that there might be a bit of a delay. Yeah, and as I said, the master usually won't decline the sale unless the heirs haven't consented, or if the property's been disposed of at much less than its value, and they will check that. Okay, so there may be a reason. It may have been on the market for a long time. Maybe the municipal value is much higher than its actual value. It's dilapidated. So there are instances where it's all right, but they might check that. Okay. And that is it. Please, can you, I just want to stop this quickly.